Do we have too much government?
We need to put people ahead of corporate profits.
This system is so lopsided.
This threat is a real threat to democracy.
And I think that's really important. That's something we haven't been doing in this country for a long time.
Where do you start? What do you do? How do you do it?
Access to Democracy and other Eagan community television programming is supported by Thomson Reuters, makers of Westlaw Next and based in Eagan. Through Westlaw Next and other innovative online services, Thomson Reuters is the world's leading source of intelligent information for businesses and professionals. Online at thomsonreuters.com. And by U.S. Federal Credit Union, the member-owned financial institution offering service, value, and experience you can trust to the greater Twin Cities community.
Welcome to Access to Democracy. We have our favorite judge and certainly our most frequent judge with us today, the Honorable Paul Anderson of the Minnesota Supreme Court. And welcome back.
Well, thank you. And if I may make a comment at this point, Alan, is that you've really given me a gift as I'm approaching retirement, mandatory retirement for the court. I have this historical record as my service on the court through these interviews at Access on Democracy. I really hope the Historical Society or some other entity preserves these records long term, because you've talked to so many important government officials, and I'm grateful that I have this historical record for myself.
Well, I appreciate that, and I do wish we have 1,300 interviews.
1,300.
Available free for any historical society that will take us up on it.
Well, I hope they do.
I certainly hope they do also. And welcome back again. You have been, well, you're the second senior judge on the court. And you've been all over the country, all over the world lecturing. But let's talk about, you were appointed by Arne Carlson, a Republican judge. And yet you are probably known as one of the most liberal judges on the court. Of course, the Republican Party has changed a lot since you became a judge. But number one, you've been involved in several important minority decisions, which we talked to Judge Strass about last week, as a matter of fact, who was in the majority, and we'll talk about them in a moment. But around the world, you have been to Africa, you've been to Syria, you've lectured all over there.
Not Syria yet, hopefully, maybe.
Oh, I thought it was Syria also.
No, Tunisia and Libya, Philippines,
okay,
Russia, China.
During that period of time, you got to know our late ambassador, I believe.
Yes. I thank you for asking that question, Alan, because when I went to Libya, I had occasion to meet Ambassador Chris Stevens. And I mean, you meet him, you're just enthralled. He is everything what they say about him. He is what you want the American image to be abroad. He spoke Arabic, he was involved with the people. Maybe, you know, is just a little too comfortable with his interaction with the people, because a lot of militias in Benghazi. I mean, I was cautioned. My wife was really worried when I was there. But oh, what a marvelous person, and it's such a great loss. The irony is, there were probably people rioting outside of the consulate office whose lives were saved by his willingness to go into Benghazi early on.
It's beginning to look more and more as though he was targeted, because he was too popular, and he was too well-liked, and he was too Western, and there are a lot of people that don't want that influence.
There was a very interesting development lately, because he was beloved in Libya. A number of Libyan citizens actually marched on the militants' headquarters and ousted them. And as the latest is that they've kind of, in the way that these militants do, they've kind of disappeared into the landscape. But the Libyan people came to the defense of the American and saying, this was a good person and we don't want you militants here.
A tragic loss.
Yes.
But coming up through the ranks of the GOP. Did you have heroes?
Oh, absolutely.
Who were your heroes in the Republican Party before you took the bench?
Oh, yeah. I mean, Harold Stassen, of course. I mean, it's one of the 8 American emissaries to the UN Charter. I mean, he was a reformed civil service. Luther Youngdahl. I mean, now, Luther Youngdahl is interesting. He was known as the Blue Nose, the Christian, the governor, the Sunday school governor. But in 1947, Luther Youngdahl said, you know, we need to start realizing there are people different than us around the world. We've got to treat them well. Oh, and by the way, we might start here in Minnesota with the Native American people. And by the way, is it, you know, integration of the Army?
A fellow by the name of Hubert Humphrey had the same feeling in Minneapolis at the same time.
If you look at President Truman's back, there was a big handprint from Luther Youngdahl saying, integrate the Army, because I'm integrating the National Guard. And Elmer L. Anderson, I officed with Harold Levander. Al Quie is a mentor and a hero. I mean, across the spectrum, but, you know.
Arnie Carlson.
Arnie Carlson. Oh, absolutely. Arnie appointed me. But I said, I come out of that populist, progressive Minnesota Republican tradition. I'm gonna comment, and you said, is that I'm the most liberal on the court. I'm not afraid. I don't run away from the word liberal. But I was teaching a class at William Mitchell, and a couple of public defenders were there. I was teaching them, and the question came up of them is that, well, who's the most liberal member of the court right now? And one of the teachers says, well, there's no doubt about that. That's you, Justice Anderson. So I'm going on continuing teaching. And I turned to her a little bit later and said, Melissa Sheridan, she's from Dakota County, said, Melissa, my background's Republican. I'm an Eisenhower Republican. How can you say I'm the most liberal? Or how can you say that I'm liberal? Well, she said, oh, Justice Anderson, I didn't say you were liberal. I just said you're the most liberal on the court, which maybe is an indication as to where the court has moved. But it's a subtle but important distinction that I repeat sometimes because I think she was quite perceptive there.
Now, you've been on the court for well over a decade.
Oh yeah, approaching 2 decades.
Approaching 2 decades. What's the toughest decision that you've faced in your time on the court?
That's a very interesting question. I mean, a lot of tough decisions, some of them factually tough, some of them sorting out the law. I think I may have mentioned is that our confinement of sexually dangerous people, we do that under a civil commitment, and is that the right of due process and treatment, it's pretty close to the edge of constitutional protections. In fact, the federal court has told Minnesota they got to start paying attention to it. But there's a recent case that I found quite vexatious. I mean, I have a line in the opinion. I said, this is the voter ID election case, and I said it's among my most vexatious. You know, I originally wrote that line. I said, the most vexatious. But it's close, maybe is the most. But that case has bothered me a lot.
Well, we've had 2 cases, really almost companion cases. League of Women Voters against Ritchie, our Secretary of State, and Limmer against Ritchie, our Secretary of State again. One on same-sex marriage and the other on the voter ID, which really it's much more than a voter ID case in my mind, but it's a suppression of the vote case in my mind. What the legislature did to me is try to keep thousands, if not hundreds of thousands, of people away from the polls.
Now, I'm not going to get into the merits one way or the other with respect to whether you vote yes or no on those amendments. But what is bothersome to me about the way this has been set up and positioned for the people of the state of Minnesota, let's talk about the League of Women Voters case,
Okay.
a voter ID case, is that it is conceded that the question as being put on the ballot is inaccurate, misleading. The majority conceded that. I mean, I found it also deceptive. And I went to the Constitution, our basic, most fundamental law, and it says the constitutional amendment will be submitted to the people. On the gay marriage amendment, the language is there. The people will see the language. That's fair. On the voter ID one, they're going to see an inaccurate, a misleading and, I conclude, deceptive question. That is
As
not
phrased by the legislature.
It's phrased by the legislature. See, and our Constitution is our most basic law. And see, the reason we have constitutions and basic fundamental law, Alexander Hamilton, our founders understood that a constitutional democracy like ours could be subject to the ill humors of the current majority. And so you have a constitution which is something to be enduring, and it should be difficult to change that law, but surely you shouldn't do it in a way that's deceptive. And I read the Minnesota Constitution, and I concluded the people are entitled to see the language of the amendment before them as they vote on it. Instead, they're going to get an inaccurate, deceptive, and misleading statement. And they will also have a title that I think is deceptive.
Well, the strange thing is that the statute, as I researched it and looked at it, is very clear that the Secretary of State, going back almost a century, is given the authority to create the title for a constitutional amendment. And what the court did here is not only take that authority away from him, they absolutely castigated him for doing what I saw as his statutory duty.
I use words that you say very clear, castigated, but I see is that I think, you're talking about the second case, the Limmer case, the title case.
Yeah.
And I absolutely could not find either in the Constitution where the legislature could do what it was doing. See, the Constitution, Article 9, says that the legislature gets to draft the language of the amendment and they submit it to the people. That's where I say the people get to see the amendment. Now, what happened in Minnesota in 1919, other than Prohibition, was that the legislature, under Article 4, Section 23, both majority houses, passed a piece of legislation, that's 204, said that the Secretary of State shall design the title for any constitutional amendment going to the people. And the Secretary of State will do that with the advice of the attorney. It didn't say you may, it says he shall. He or she shall.
Requires the Secretary of State to provide an appropriate title for each question printed on the ballot. The title shall be approved by the Attorney General and shall consist of not more than one printed line above the question to which it refers.
So what Secretary of State Ritchie was doing was following the law. And that's what I had some problem with this, the language in the opinion, and bear with me a minute, is that I thought it was so unfair.
You had lengthy dissents in
both
of these cases.
But I thought it was so unfair for the court to say that we hold the Secretary of State erred and exceeded his authority when he provided titles for the ballot, when the Secretary of State is following a statute that he's mandated to do something, a statute passed by the legislature, approved by the governor. See what the
that's really gratuitous dicta in a case.
Well, I won't call it gratuitous.
I just did. You don't have to.
But I think it was see, we don't do that to our fellow government officials. We get enough legitimate criticism for what we do. But, you know, we shouldn't criticize somebody for following a law that says you are supposed to do this. See, and the subtleties of this case were that the legislature knew that it couldn't change the statute because Governor Dayton would veto it. So what they did was when they proposed the amendment, they included their own title. We call that an attempt to repeal a statute by implication. I got a cite to Scalia and Garner and others say, you don't do that. I got case law. No, you can't repeal a validly enacted statute by implication. You got to live with what the statute is. And so, okay, you can disagree, but to criticize the Secretary of State for doing what the legislature and the governor told him to do, I thought was unfair. Now, if I feel a little passionate about this and how this whole thing plays out, excuse me, but see, Alan, in June I was in North Africa. I was talking to people in Libya about election fraud. and how to avoid institutional means by which you deprive certain voters of the right to vote to amplify the vote of others. I've talked about the continuum of fraud, malfeasance, manipulation, and incompetence and negligence that happens you said, people say we want to be like Minnesota. We are a model. And then to come back to Minnesota and deal with an issue like this is, I found that vexatious and troubling, because I love this state and I love the concept of rule of law we live by. And people are entitled to know what they're voting
on. To be
on
the short end of a 4-2 decision, one judge did not participate. Normally
we had a judge who retired, right.
Right, and there's a new judge who has not participated yet.
She just got sworn in the private ceremony yesterday.
Oh, is that right?
Yes, and she will be formally invested in on the 16th of October. Mimi Wright, she's going to be a real good person.
And it's interesting, I asked Judge Strauss last week. Now, we really have some intense rhetoric here. The language got really, really heated. How do you people deal with each other the day after? And he said it's very collegial.
Oh, very collegial. Actually, he and I were meeting with a reporter who was getting some background on how the court does its business yesterday, and she was astounded how collegial we were in manner. I mean, but we just, you disagree and you move on. See,
you accused the court of really implementing Alice in Wonderland type.
I didn't accuse. I did not. That's your language.
Did you use the language Alice in Wonderland?
Oh, yeah,
yes or no?
Do you have? I used the language Alice. And Justice Page said what was happening here was a bait and switch.
Right.
He referred to the majority opinion as nonsense, and
that's pretty strong language.
I didn't use that stronger language. I said there's a certain surrealistic aspect to this decision that perplexes me. It's like Alice in Wonderland had taken us by the hand, and we'd walk through the looking glass and fallen down the rabbit hole, and up is down and black is white, and we've kind of turned the law on its head. And I did that not as a measure of criticism, but as to try to illustrate to the people in understandable terms that what's happening here is to have the definition of close enough include inaccurate, misleading, and deceptive. That's not right.
And in the other case, which the gay marriage case, for lack of a better terminology, we have a law on the books that prohibits gay marriage, which there was a great column in the Star Tribune today, as a matter of fact, to this effect. But the law, as I saw it, as passed, was so general, it really was not a complete law. Now, we also have statutes that say that a law can only have one topic and has to speak for itself. Well, it didn't define a polling place. It talked about provisional ballots. It didn't tell us specifically what a voter ID would be, or how we would get it, or how the cost would be borne. So to me, those were glaring defects in the law. Now, obviously, I'm not in the majority.
Yeah. Well, you're mixing two things here. And first of all, I talked about the gay marriage amendment. There's not going to be ambiguity about that amendment. Whether you think it's constitutional right, the full language of the amendment is going to be on the ballot. The people are going to know what they're voting on. So I don't get as exercised about, because the legislature did it right. They put the full amendment, whether you agree with it or not, is going to be on the ballot. But what you put your finger on is that on the voter ID ballot is the deceptive. Nothing in the description talks about provisional voting. A sea change in how we handle voting. It refers to a free ID. Well, there's nothing free about that photo ID. I mean, somebody who lives up in Ely and has to go to Virginia or to Hibbing in order to get both a birth certificate or whatever, or someone like former Governor Arnie Carlson, when he no longer has a driver's license, his birth certificate says baby boy. He is going to have a hard time getting evidence, but it's going to be costly, the process, okay? And is it, it's so inspecific. We're going to go to Europe in October, so I happen to have my passport because I have to do some work to get that done. I have been informed that my passport, now I always consider this to be the gold standard. I mean, this gets me back into my country. This says that I'm a citizen, but discovered it doesn't have my address on it.
So you might not be able to vote if that's what you had to rely on.
Well, I still have a driver's license, so I think that will work. But that's part of the problem with the deception and the misrepresentation and how the amendment is described. So now you can maybe get a little bit of a sense why. Quite honestly, the people can vote on that amendment however they want. They can decide it. But they need to be informed as to what they're voting on, and that's what is problematic. Can I read something?
Absolutely, and while you're looking for it, I would just say, and it's my words, not your words, but we in the legislature are seeking to create a fix for a problem that doesn't exist, intended only, and led by a former Secretary of State, which really irked me.
But I don't care who's backing it. It's just the context of what it is.
To keep people away from the polls.
Now, here's another thing, is that I had the opportunity to ask the attorneys if they could give me one example of in-person voter impersonation fraud that this amendment would have an impact on. They started to give an example that was bogus, and I pointed out that it was, and they quickly stopped. I had no example of any fraud that this would cure. But I want to point out something about this whole issue of...
I've heard some of the supporters say, well, we might have this in the future. Well, the sky might fall in the future also. So, I mean, to seek to put that into legislation to me is ludicrous.
Now, you mentioned Justice Strauss during oral argument. I tell you, he asked this question about, labeling and describing something. He said, if the legislature passed a proposed constitutional amendment that provided funding for trails in Minnesota, the legislature could not submit a ballot question to the people that stated the proposed amendment was about flying people to the moon. So you got a funding of trails. They put on the description flying to the moon. Here's what the attorney's response was. At oral argument, the counsel claimed that such a ballot question may or may not violate the Minnesota Constitution.
Which says nothing.
Well, but it's absurd. I mean, be able to put a ballot question that's funding for trails and describe it as flying people to the moon, no. In my world, that does not meet the constitutional standard.
Nor in mine. And I'd love to talk about these for another half an hour, but let's move on. I noticed that decision...
just one point,
Yeah.
I just got to explain my passion. The Constitution is so special. It is the guarantee of our rights. I've stood with people in a square in Tripoli where they've been shot at in order to garner the right to vote. I've seen people risk their lives, and I understand how precious this right is, and I really feel it's my duty and obligation.
And you stood in Tiananmen Square also, and we remember what happened there.
So I take my duty seriously.
And I just got the 5-minute signal from Mary, so
okay.
I see a decision as these were per curiam, which means that the court...
That's a Norwegian judge that serves on the court. Per
curiam?
No, I'm kidding.
It means that the judge who wrote the decision is not identified.
Mm-hmm.
Is that because no judge wanted to be identified with these two decisions, or is it because it's the opinion of the 4 in the majority?
It's mixed, and I mean, I'm not one who buys into these conspiracy theories or worries about it, and I wouldn't get overly exercised the fact that it's per curiam. Maybe it's a little bit odd, whatever, but sometimes in big major policy decisions like that, the court will decide to do it per curiam. We did that in Coleman Franken, but they're all of the court. And I can tell you on Coleman Franken, there were so many different, all of us were part of the authorship, that anything other than per curiam would be inaccurate. But the majority decided that this case fit in that category where the majority could label it per curiam. And so they did. It's more about how courts do their business, and so I wouldn't get overly. A lot of people are talking about. I wouldn't get overly exercised about it, though.
Now, we've talked a lot about free speech, and before we went on, I asked you, for instance, do the royal family of England, do they have the right to privacy when they're vacationing and some paparazzi photographer 600 yards away and hidden takes a picture of them with or without clothes on? Do they have a right to privacy, or is that an invasion of free speech?
Well, you would think that they would. I mean, this is such a dicey question, and of course you can bring it up in the context of.
That's why I give it to you.
Yeah. But I mean, and they have different libel laws, standard laws, and privacy laws in England. If you are a person who is, is at some celebrity status, just be careful wherever you are, because is it electronic intrusion? By the way, that's one of the most interesting issues coming before the courts, is as far as search and seizure. What is illegal search and seizure with this technology? And under the criminal law, that would not be illegal, because it's like photographing you on the roof with a helicopter from that distance. Having heat-sensitive monitor that can penetrate your house and see if you have heat lamps growing marijuana, the court has said that's an intrusion. So it's a very difficult drawing of the line.
In only 2 minutes that we have left, what about the movie or the 14-minute short that incited all these riots in Africa? My feeling is that under Schenck versus United States, Justice Holmes said you can't cry fire in a crowded theater. I think the person who made that movie was on notice that his conduct, particularly against the Prophet Muhammad, was engendered to get just the type of reaction it did. And I think that that person is liable for prosecution.
That is such a difficult question. First of all, in the United States, we have some of the most liberal free speech laws because we encourage. I mean, that's how we correct ourselves, is if somebody is doing something stupid, we have free speech, you can correct it. One of the things that causes the problem in the Arabic countries and other countries, and I saw this there, their concept of free speech is so much narrower than ours. When something like this happens in the United States, they cannot conceive that the United States is not complicit in it because it happens. Because in their country it'd be unlawful and immediately the person would be arrested. And so you draw the line in a little place. I'm not sure where I draw the line. You might be right. It might fit within the Schenck crime. But you got to be very careful, Alan, as to where you draw that line, because if you stifle too much free speech, we can't correct our mistakes, and that's one of the ways we correct it. But this was a reprehensible, horrible type of doing. Maybe maybe we can talk about it again, because once again, as we always do, we have run out of time. Justice Paul Anderson, thank you so much for coming in. It's always an education, and come back again soon. Always enjoy it, Alan. Thank you so much.